So the first speaker that I'll call is Kevin Bowling.
Good afternoon, and thank you for the opportunity to comment on the strategic agenda. My name is Kevin Bowling. I've been a court administrator in Michigan for 48 years. I support the council's 6 priorities. They provide a sound framework for Michigan's judiciary. My principal recommendation is not to add another priority, but to strengthen implementation across all 6. And there are 3 points I'd like to emphasize. First, recognize effective court administration as a strategic capability. Statewide policy matters only when it can be successfully implemented in individual courts. Funding reform, technology, access, workforce development, accountability, and public trust all depend on capable leadership, adequate resources, and the capacity to manage change. Second, measure success by outcomes experienced by the people Michigan courts serve. Success is not simply launching a program, installing technology, or completing training. The real questions are, can people understand and navigate the court process? Are they treated fairly and respectfully? And can their cases be resolved without unnecessary delay? For that reason, I encourage the council to make timely justice and effective case flow management more explicit. Delay affects many things: fairness, cost, access, workload, and public confidence. Timeliness is not merely an efficiency measure, it's an essential component of justice. Third, approach modernization and funding through the lens of statewide equity and institutional capacity. Technology should improve and simplify court services, but not merely automate existing processes. It should also include accessibility, cybersecurity, continuity of operations, interoperability, and responsible AI governance. Likewise, Michigan courts need stable, predictable, and equitable funding so that meaningful access to justice does not depend excessively on the fiscal capacity of a particular community. Finally, the operational plan should identify meaningful performance measures, clear responsibility for implementation, and transparent reporting. By 2029, I suggest one simple test of this strategic agenda. Is Michigan's judicial system demonstrably more accessible, timely, understandable, equitable, resilient, and trusted by the people it serves? If the answer is yes, this agenda will have accomplished something important. Thank you for your leadership and for inviting public participation in this work.
Next speaker is Jody White.
Hello, thank you. Instead of just words in this following agenda, we need to start taking actions. I want to speak today on 2 of the 6 pillars in your strategic plan: fairness and accountability, and public trust and understanding. Because in Michigan's probate court, they are the same problem wearing 2 names. When a family loses a loved one, they don't just grieve. They're handed a job of marshaling assets, accounting for every dollar, and distributing a lifetime, sometimes generations of wealth, fairly and under lawful procedures. To help them, they hire a professional who charges to know the legal process. But that professional holds no special probate license. They are only members of the State Bar of Michigan and nothing more. Membership is not oversight. It shouldn't be treated as if it were. Canon number 1 of our Code of Judicial Conduct says the judiciary exists for the public, not for itself. The principles has to extend past the bench to everyone. The court relies on to administer justice: the lawyers, the fiduciaries, the guardians, the conservators. A lawyer's oath is not a courtesy, it's a standard. I've watched this gap up close. In an Oakland County probate matter, a court-appointed co-trustee was convicted of conducting a criminal enterprise in 2024. His fellow co-trustee, a bar member, officer of that same court, has faced no charges, no audit, and no review, and he continues to practice. This is not an isolated failure. It is a pattern, and it tells families that accountability stops at the courthouse door for everyone except them. And this just is not about lawyers. This June, the JTC closed 4 separate investigations into an Oakland County probate judge. Their letter doesn't say the complaint lacked merit. It says that the judge's term expires this year and he's ineligible to run. So, hey, due to his impending retirement, the commission is taking no action. Not because nothing happened, but because he's leaving anyways. That is the accountability gap in one sentence. Today, a citizen's complaint against a lawyer to the AGC or against a judge at the JTC level is confidential. The public cannot see it, and it can be closed for reasons that have nothing to do whether the conduct occurred, while the family that filed it, still grieving, is left with no answers at all. If we want public trust and understanding, the public has to be able to see what happens to these complaints. Sunlight is not punishment, it's oversight. And oversight is what turns an oath into a standard we can actually measure. In closing, as a Michigander since 1963 and as a candidate for this court, I'm expecting transparency and professional accountability, real audits of fiduciary conduct, and a probate system that protects families first. Because the administration of justice starts with every professional. The public pays to trust, working in the same light they would ask any other professional to stand in. Thank you.
The next speaker we have is Brandy Ritsema.
Good afternoon. My name is Brandy Ritsema, and I have personally been experiencing what happens when access to our courts depends on individual discretion instead of equal standards. I requested Zoom as a disability accommodation and provided supporting documentation. The judge denied me, stating that me appearing by Zoom affected the decorum of the courtroom. Yeah, that same judge uses Zoom, and during the same proceeding where I was denied Zoom, other people were allowed to appear by Zoom. Then for a proceeding involving my minor child, I was ordered to appear by Zoom and warned that there would be consequences if I didn't. I complied, and then I wasn't allowed into the proceeding. So Zoom can be denied when I need it for a disability, permitted for others, used by the judge, and required of me only when the court chooses. How is that equal access? I have also been told I don't need court audio because the transcript is the official record. But disability access is not about what format the court prefers. Audio helps me process, understand, remember, and review complicated information. Transcripts can also cost hundreds or thousands of dollars. When disabled and low-income litigants cannot afford them, denying reasonable access to existing audio creates another barrier to justice, and recordings provide something else, and that's accountability. The court records us, yet judges can restrict our recording, restrict access to their recordings, deny remote access, and then tell us to purchase transcripts. When there's a dispute about what was being said or what was omitted, or when something appeared in the court record, how does an ordinary person independently prove what actually happened? I have personally encountered and proven record discrepancies that I believe warrant independent review, and it goes ignored. Transparency protects everyone, litigants, judges, clerks, and the integrity of the courts themselves. Family court, probate court, juvenile court, criminal court. Some proceedings legitimately require confidentiality, especially to protect children and vulnerable people. But confidentiality should protect vulnerable people, not eliminate accountability for government conduct. Judges administer our courts, they do not own them. The ADA requires meaningful access to government services, and our Constitution demands due process. Michigan needs consistent statewide standards for disability accommodations, Zoom, public access, and affordable access to court audio and video. Justice cannot depend on your disability, your income, your county, or which judge's doors you're walking through or standing before. A right cannot meaningfully access. A right you cannot meaningfully access is only a right on paper. Equal justice requires equal access, period. Courts are public institutions exercising government power in the name of the people. And when they have the power to separate families, restrict liberty, control property and equitable rights, and fundamentally change people's lives, equal, meaningful access is no longer optional. Thank you.
The next speaker is Janice Daniels.
Hello, thank you very much. With all due respect, Chief Justice Megan Kavanaugh, for you to begin your Michigan Judicial Council 2026 to 2029 strategic agenda calling America or Michigan a democracy is repugnant to the principles of our American Republic. Words of the Republic matter. It concerns me greatly that the chief public functionary of the Michigan State Supreme Court is either unaware that America is a republic, or she has bought into the distortion of our Constitution and our sacred rule of law that is supposed to govern the behavior of our public functionaries so that they can secure the blessings of liberty that God has given to each and every individual of our union. And I question the creation of a, quote, behavioral health administrator, unquote, position in the state court administrative office that is coordinating system-wide efforts to address how courts respond to behavioral health needs. In my humble opinion, the role of the judiciary is to adjudge the constitutionality of laws brought before them, not to manage behavioral health needs or to design funding schemes that give special treatment to so-called indigent people. The law is to be equally applied to all persons. It is not the government's job to pick and choose winners and losers. The spiritual, financial, and mental health of the community is more of a role for the clergy or the family, not the courts. I would like to see the judiciary stop with the so-called progress and change the direction you're taking to start peeling back the layers and layers of bureaucracy that have distorted our rule of law and our pursuit of justice. I know it's in your psyche to build a never-ending administrative state rather than to simplify justice to your proper role of adjudicating constitutional fidelity, but I will continue to pray that I will have planted some seeds for some of you who really want to provide justice by protecting and defending our Constitution rather than building a big government behemoth that we the people don't want or need. Thank you.
Our next speaker, Charmin.
I'm just a country singer from Nashville who come home to take care of my mother with no help. I have been in and out of the courts trying to protect my mother, and all they did was take her away from me through incompetent people that only know how to collect their money, not take care of them. I've been noticing since I've been involved with the advocates like Jody White and Tom Howe and Cynthia Mifsud that, you know, there's a lot of talking going on here and there's a lot of ears open, but nobody's doing anything about anything that they're saying. And I agree with everything that Brandy and Jody White has said. And so I don't know if your hands are tied or everything's still such a secret that nobody can do anything. But how do we get this secrecy out of this? There's no business in the courts for secrecy. As everybody said, it should be an open court. We should be able to get things done. I wouldn't be able to do this if it wasn't for advocates, because I would have already given up. So I just suggest that y'all turn to God in every form of fashion that you feel you can. Nothing is lost. God is there for, the Heavenly Father is there for all of us to stop this secrecy. So I just want to say that I hope that we can finally get something done. I do know that we're finally getting judges charged for this behavior, and our former Democratic Treasurer Tracy Kornak being charged. So we're seeing some things get done, but the people need something done too. And it needs to happen fast, and us not just run our mouth. We need the ears to listen and to do something about it. So thank you very much.
The next speaker that I have listed is Samantha Hallman.
Hello, Justice Kavanaugh and other members of the Michigan Judicial Council. Thank you so much for this opportunity to share ideas about how to improve our court systems. I'm here today to recommend that the court adopt a statewide policy of presumptive public access to copies of audio and video recordings of public court proceedings that are already being made by trial courts using technology that is purchased with public tax money. This policy is really important because it's grounded in our First Amendment rights of access, and it's at the intersection of many, if not all, of the MJC's priorities. Specifically, it helps address the MJC's goals of fairness and accountability, public trust and understanding, workforce excellence, and effective problem resolution by ensuring that citizens who are independent of the court system have a reasonable opportunity to observe their democratically elected judges in action, ensure that proceedings are being conducted fairly, identify problems, and effectively communicate problems with others so that they can be resolved without fear of retaliation. It also helps address MJC's technology goal. The MJC specifically notes that as technology rapidly shapes how people communicate, receive information, and access services, courts must embrace these advances to preserve timely, fair, accessible, and transparent justice. Unfortunately, as MCR 8.119 is currently written, it allows individual courts to circumvent all of these objectives by needlessly requiring court reporters to transform accurate verbatim recordings into written transcripts. This process takes much longer than simply sharing a copy of the digital record with us, substantially increases costs, and strips the record of relevant context and sometimes accuracy as well. While those who demonstrate resistance rely on hypothetical problems to justify denying access, the actual real-world evidence indicates that these purported concerns are either non-existent or easily solvable. Many other states have implemented a similar policy, which should assuage any concerns and serve as examples for us to emulate. I have examples. I only have 2 minutes. I was going to go for 3. I'm happy to share those upon request, and I'm really grateful for your time. Thank you so much.
The next speaker I have is Nicholas Somberg.
Thank you. So my name is Nick Somberg. I'm a trial attorney in Michigan, and I agree with some of the previous speakers that regarding public access and fair use of technology, I believe that every court hearing, just by default, should be live streamed and digitally recorded. Obviously, with exceptions for kids or sensitive matters, if it's something where we could close the courtroom doors, obviously that's not going to be on Zoom. But the court's supposed to be public, and if somebody has to take work off and drive there and drive hours to park, that I don't think that passes the definition of public access anymore. It's 2026. We don't need to use tape recorders. We're not using old technology. It's extremely cheap, simple, widely used. A few cameras and an internet connection and a cloud subscription can solve all this very quickly. A mother in Detroit should be able to watch her son's hearing in Marquette. A journalist should be able to observe a small court up north just as easily as a courtroom in Detroit or Lansing. This also increases transparency and accountability, especially in places where there's less day-to-day public oversight. Right now, judges have broad discretion to deny Zoom, and it is a judge's courtroom. But when Zoom was new, I think this made sense. But now we have years of experience that remote appearances work. So kind of the bugs of things not working or it causing delays, a lot of that is actually worked out by now. And people are very used to that. And I disagree that that an individual judge can now just deny Zoom just because. And right now I have to fill out a form and to see if they request it. It should be the default acceptable way unless there is some sort of other compelling reasons. Another thing is regarding people's counsel of choice. There's people up north that want to hire me, and I'm happy to do that. But there's some judges, not all, that say, well, you're out of county, you're far away, that's your problem. And I'm happy to go there for a trial or an evidentiary hearing, but there's these little 5-minute court dates adjournments, and a judge won't approve Zoom. And I feel like that's effectively denying my client their right to the counsel of choice, or making it so expensive, like, okay, well, I got to drive 6 hours round trip for an adjournment. Doesn't make sense. The other thing, besides Zoom, and I'm happy other people talk about it as well. Is one more thing on Zoom is that I've actually been told I had to appear in person and drove 3 hours, and I have a prosecutor on the screen on Zoom who's local. And I'm like, what? Like, oh, well, this person's got their kid broke their leg. It's like, okay, well, then everybody gets Zoom. It can't be inconsistent. It can't be one or the other. It has to be equal. Whatever the rule is, it should apply to everybody equally. And lastly, late judges. My gosh, it is so disrespectful. And as a lawyer, it's like embarrassing to the legal profession to have a judge stroll in at 10 o'clock, 10:30. I won't name names or cities, but there are certain places notorious for this. It's embarrassing. There should be consequences. If you say 8:30, show up at 8:30, 8:40. Okay, not 10:30 when you got 30 people sitting there waiting for you.
The next speaker we have is Thomas Howe.
Thank you. Thank you, Justice Megan Kavanaugh. I appreciate it. It's clear in Michigan here in southeast lower Michigan and Genesee, Oakland, Wayne, Macomb, also Kent County, Berrien County, is that our probate courts are running a RICO theft ring operation. We just had one judge, Kate Ryan, the disgraced Kate Ryan, who was removed from the bench by the Judicial Tenure Commission. It wasn't because of all of her actions that she's done over the years and all the complaints that came in. It's because of one clerk of the court doing something, and he's a hero for getting rid of her. Now, the Judicial Tenure System has not brought her in forward, and she needs to be prosecuted by this court. Now, the last person you prosecuted and put in prison was Teresa Brennan 7 years ago. Now, these courts know that this court will not prosecute any of these criminal judges who are out there robbing people across the state of Michigan. We've had multiple cases of houses being robbed. We had one this last week that we know about. I've had one. We've had another lady who got evicted from her house. These people are all homeless. These are elderly people who can't defend themselves if their life depended on it. They couldn't fill out a court form if someone tried to help them. And these are the victims that they're going after. This is where the Michigan Bar Association is running a RICO theft ring operation. And they're doing it with these judges. And these judges, there's no recourse in the state of Michigan. The Judicial Tenure Commission won't help you. They say, well, we can't get involved in a court decision. Well, who can? Well, we take it to the appeals court, and the appeals court turns the decisions around on appeals of right, and you lose. And of course, we all know that you have a 4% chance if you go to the Supreme Court to get your case heard. But if you review all the cases that you have on YouTube, there isn't any probate court cases. So the Supreme Court is systematically eliminating all the cases of probate, because that's the monster theft ring operation where they're stealing hundreds of millions, if not billions of dollars a year from the public with no authority to do so. So I'm asking you, are you going to do your job as a public functionary? Because that is your critical job, is to oversee every court in the state of Michigan. And you're not doing it. And we've asked since the 2020 pandemic. We were at the listening tour back then, and we asked the same questions, and not one damn thing has been done. And matter of fact, it's actually gotten 3 to 10 times worse. And now they actively attack people in court. They go for summary disposition prior to discovery, which is not legal in the state of Michigan. And there's cases all over the place. I mean, they just cause vexatious litigation all over, and they never let up. And they try to take the cases and the trusts and destroy them and turn it into the bar card profit instead of giving it to the people. Now, remember, these courts are for the people. We own the courts. You don't. You're a public functionary, and you swore an oath to the United States of America and to the state of Michigan Constitution. So help me God. And I believe the Supreme Court is not doing its job. It's never done its job. It's never taken control of the appeals court. I just had appeals court judge, the chief Supreme Court judge, aiding and abetting a law firm. We caught him red-handed, and they said, "Oh, that's nothing." And then they turned around.
You're at 4 minutes. If you want to.
This is what's going on in Michigan. There's no moving to 2009 or 29. We can't even get past today, and we need to fix this immediately. This is just a criminal theft ring operation is what's running here in Michigan, and this needs to stop immediately.
Thank you, Mr. Howe.